This is a regular Development Commission meeting. We have several items on our agenda tonight, some regular business and minutes, etc. And then opportunity for the commission to learn some things about the Open Government Training Act and other essential training with respect to being on the commission. Also an opportunity to answer questions as we go through the sessions this evening. And we'll conclude this evening with election of the chair and the vice chair on the commission. So first of all, I hope everyone's had an opportunity to review the minutes from the April 12th meeting. It was a brief meeting, so the minutes are relatively short. So are there any amendments to the April 12th meeting minutes? Hearing none, the minutes are approved then by consensus. So we're moving right into our training session. So I will hand it over to the city clerk, Tisha Geiser, and the city attorney, Rachel Turpin, who I believe are leading this section. No, Lucy says.
I believe we need to do roll call first.
Oh, thanks, Lucy.
Yeah.
Roll call. Would you please do the roll call?
Certainly. When I say your name, please say here. Commissioner Shore.
Here.
Commissioner Dillon.
Here.
Commissioner Price.
Here.
Chair Brennan.
Here.
Commissioner Gilbert.
Here.
Commissioner Ikeda is excused. Commissioner Sanford.
Here.
Commissioner Morgan.
Here.
And Commissioner Silverman is excused. In Commissioner Ikeda's absence, Commissioner Morgan is acting as a regular member this evening.
Great, thanks, Lucy. Now we can move into the first agenda topic, Open Government Training Act and other essential training for the commission.
All right, thank you, Chair Brennan. I'm going to ask Lucy if you don't mind giving me screen sharing privileges. I do have a PowerPoint to share tonight.
I wasn't sure who was going to be doing that.
You don't want me to do it.
And while that's getting going, I want to start by thanking you. I know, commissioners, that you had some very robust and are continuing to have some very robust meetings on items before the city, and just want to thank you for your service. I also staff the city council meetings and hear their thanks to the commission members as items that you've considered move up to them. So I want to start off with that. And the training tonight, I know most of you have received multiple times, so I will try and have stay very high level here. Give me just a moment to get my screen where I want it. Right, one more change here. Got three monitors, which always makes it a little complicated. Okay, great. All right. Okay, so yes. Oh, are you still seeing my notes slide? Okay, let me try that again. Oh, it's funny. It won't change it. Give me a second here. Let me try it one more time. Is it clean now?
No.
No. Oh, that's interesting. Okay, I'm sorry. Give me one more minute. I've done this many times, but you know, sometimes there's just unforeseen.
Technology doesn't always want to cooperate.
Yeah.
Yeah, Tisha, it's happened to me when you have like two open, two same PowerPoints open. For some reason, it gets confused.
Okay, so I'm going to check that. Okay, clear. I closed a monitor. I'm going to try it again. Give me a minute here. Okay. Okay. One more click. Gosh, it's still doing it, isn't it?
Well, we'll just get to see your.
There you go.
Oh, there it is.
Did it work? Okay, awesome. All right, thanks for your patience with that. I'm sorry. But the slides are helpful. They're going to help me and Rachel stay on topic here. So, all right. So, as I mentioned, many of you have received this training before. Melanie, you are getting this information for the first time tonight. So please let us know if you have any questions. And I presume that the other new commissioner, Eddie, will review the video as well. So the purpose of tonight's training is to cover some required training, as well as just touch on some facets of commission membership that we think are important to review and certainly cover with the new members. As Lucy, or as the chair mentioned, Rachel, who is our city attorney, and I will provide today's training. I know you received a similar training last year with both of our predecessors. So again, I'll try and keep this pretty quick. So the purpose of the first portion of the training is to talk for a few minutes about the state sunshine laws, and those are the Open Public Meetings Act and the Public Records Act, both of which are really aimed at ensuring transparency in government and public access to government, and so they definitely have some relationship to your role on a city commission. We talk to you about these laws and some basic training every year because we think it's important that you have this knowledge to prevent what are often inadvertent violations of these laws. It reduces your legal risk, the city's legal risk, and to some extent is required by state law that this training be received as you're newly appointed into your positions and then routinely as you continue to serve on the commission. So some of the basic provisions of the Open Public Meetings Act are primarily that your meetings be open and accessible to the public. So during COVID and your virtual meetings, this means we publish links to your agenda, or I'm sorry, not only links to your agendas, but links to your meetings. So people can attend the meeting virtually, they can call in by phone. We publish the passwords, so there's just no barriers to access to these meetings. When you go back to meeting in person, the doors are unlocked, the doors are open from start to finish. It also means that we provide advance notice of when your meetings are occurring and the items on the agenda, so the public knows what will be covered at those meetings. Additionally, you are one of the commissions that is live streamed and televised, so people can watch your meetings live and they can also refer back to the recordings. Wanted to talk just a minute about regular versus special meetings. So your regular meetings are on the first and third Wednesdays of each month at 7 o'clock, and they've been virtual, but eventually will be back in the council chambers. Anytime you meet at a different time, date, or location, it's considered a special meeting. What's important to know about that primarily is that during a special meeting, you're more restricted in the discussion and action you can take. You can only discuss and act on items that are on your meeting agenda. And so that's something that staff in the clerk's office are aware of, and we work to ensure your agendas have the content they need so that you can do the work that is needed. But we do like to point that out as just a nuance in the law. So as I mentioned earlier, all of your meetings are, the agendas are published on the website typically 5 days in advance. Public comment is not a requirement, but it is required in your rules and regulations. They do specify that a public comment period be offered at each meeting, so that is included on the agenda, as well as any public hearings you might be conducting. This is unlikely to occur at a development commission meeting, but we just want you to be aware that there are some allowable reasons to have a closed session where the public would be not able to participate. These they relatively frequently occur at meetings of the City Council, and there's a list of certain reasons that a advisory board or governing board can go into an executive session. Again, I expect them to be very limited, if non-existent, for the commission, but you should be aware it is a possibility. So talking about the Open Public Meetings Act, it's important to talk about your quorum. So the quorum is the number of commission members that must be present for a meeting to occur. In the case of the Development Commission, that's 4 of you. That means that your meeting can't convene. It can convene, but nothing can really happen. There can't be any discussion, action, even informational presentations until there are 4 of you present. But what it also means is that you need to be careful to avoid having 4 of you present outside of a meeting. And we'll talk about some other nuances to that too. For example, if there was an event in the community that may pertain to development or growth that 4 of you happen to attend, we would recommend that you not stand together, that you not speak together in a cluster, and that in fact, possibly if it was regarding something that coming before the commission, and Rachel will talk to you more about some limitations there, that maybe even the last arriving commissioner maybe choose to get an update on the meeting at another time and avoid having 4 of you in one place. This doesn't apply to social gatherings, to traveling, but it does pertain to an event where items that could come before the commission or before the commission could be discussed. The other thing this can pertain to is what we call a serial meeting, and this is where we always want to give a lot of training on this because I think it can be easy to do. A serial meeting would be when 4 of you are basically discussing commission business or business that might come before the commission outside of a meeting, but not all together at once, but one at a time. This can happen if an email is forwarded, and essentially you are learning of another commissioner's position or sharing information about a position. That information is then forwarded or verbally shared with another commissioner, etc. We don't want that to happen, and we particularly don't want it to happen involving 4 commission members. So for this reason, we ask if you have information to share with your fellow commissioners, it's safest to route it through your staff liaison at the city. And if you're dialoguing with commissioners directly by email or phone, please keep that to 1 or 2 other commissioners. And I will feel free to let me know if you have any further questions on that. All right, so there are some penalties. These are the penalties for violations of the Open Public Meetings Act, and there are implications to action that was taken if a violation is found. So again, that's why we want to take a few minutes of your time to talk about this law and how it relates to you. And the clerk's office and your staff liaison and the city attorney remain available to you if you have questions about this in the future. So I also want to cover the Public Records Act. This is the only slide I have on this, so I'm just going to talk for a few minutes about some of the things I think are most pertinent to you. So the Public Records Act has a lot of, prescribes a lot of things for local government. So it tells us we need to keep our records organized, managed. We have a lot of rules about how long we're to keep certain records. It also tells us that we need to disclose any records that are requested, and really it is quite broad in Washington State. Commercial entities can request records from us, people across the world, really anyone, and they don't need to tell us who they are. They can ask for public records, and so this impacts you, and I'm going to talk about this in 2 ways. So one, let's talk about records you might have generated outside of city-provided information. By and large, all the materials you're getting, the city has provided, has drafted, or is providing to you in our published materials. Anything the city has or the city's given you, you don't need to keep it separately. You don't need to keep those records or keep them organized in any way. We have them. However, if there's anything you draft outside of those records, those records then could be subject to disclosure. That might be your notes. That might be notes you take. Notes you take to help you participate in the meetings are called transitory records. You don't have to keep them. You can have your notes, and then the meeting can occur, and then a few days or weeks or months later, you can get rid of them. However, if you keep them and we get a public records request, you may be asked if you have any notes, and if so, you would need to provide them. This pertains to email and correspondence as well, any kind of communication you have in your capacity as a commissioner. So that could be a text message, an email, whatever it might be. For this reason, so again, any correspondence you have that includes a city employee, that information is captured in our city systems. But if it's a connection you have with a commissioner directly or a member of the public, we wouldn't have record of that. So we do recommend that you consider having a separate email, a personal email that you dedicate to your role as a commissioner. This just keeps all of that commission correspondence clean and separated from your other personal email. I believe that some of you have done this. Another option is to just keep your commission related email very organized, so that if there was a request, you would be able to provide it quickly and easily. And this last point here on the slide is just, a comment that if you're asked to provide a search, there is an obligation to search. I'll pause there to see if Rachel has anything to add or if there are any questions.
I just can't underscore the importance of that enough, and really recommend the separate email account if you can do that. There have been instances where courts have actually forced people to open up their records to inspection by the court, in cases where maybe they didn't think that people were being honest about what they had searched. And even if you have this legal obligation to search, like Tisha said, well, you have to provide what's called a Neeson affidavit that says that you've searched things. And on that affidavit, you have to go through and you have to actually kind of identify generally the other records that you found. So you'd say, I searched this email account and I had personal emails consisting of emails to and from my, friends and family, and other personal emails too. It doesn't have to be really detailed when you get into the personal records portion of it, but it's a lot cleaner on your Neeson affidavit if you can say, I conduct all commission business through a separate account. I searched that account and I found no records, or these are the only records that I found.
All right. And I thank you, Rachel. And I'm not seeing that there are questions. Lucy, let me know. I don't have the chat open now, but oh.
Hi, sorry, I did have a question. This is Richard Sanford. I made a note on a previous training about keeping our own personal notes for about 21 days. That was recommended, I think, in a previous training. Is that still true?
The 21-day period is making me wonder if that was a recommendation tied to decisions and a potential LUPA action. I believe that if you are talking about notes relating to project specific actions, then I think that probably makes some degree of sense. But if you're talking about your notes from just general everyday commission meetings, then you really can just dispose of them the next day.
Okay, thank you.
All right. And I think with that, Rachel, I'm turning it over to you.
All right, thank you. Well, hello, very nice to be here before you. I'm Rachel Turpin, I'm the city attorney. I know that you all got to work extensively, or at least my partner Anne Marie got to watch you extensively in proceedings earlier this year. I got the pleasure of dealing with those things after the fact, after you had already handled them and done all of your amazing work. So I thank you for that. But it's really nice to be here this evening, and I will try not to bore or scare anyone too much with what I'm going to go over. The first thing I want to talk about is the city's code of ethics, which in large part mirrors the state code of ethics. So we'll talk about them essentially as one and the same. But the city's has its own particular code of ethics. It covers things such as conflicts of interest, gifts and gratuities, and political activities. When I say conflicts of interest, that kind of covers a wide variety of topics, but in general, it would be a prohibition on engaging in conduct that would either conflict with your duties as a commissioner, or could even give an appearance of conflicting with your duties as a commissioner. A lot of the conflict of interest case law has to do with monetary conflicts of interest, such as having some sort of personal beneficial interest in a project, some sort of financial interest. However, there are other ways that you can have a conflict of interest. So it's a conflict of interest to disclose confidential information that you get by via your role as a commissioner, if you somehow have, been privy to some confidential information because of it. It's a conflict of interest to be engaged in a contract that is either, it would probably, like for instance, in a commissioner's case, it would probably be a conflict of interest for you to be a bidder on a project that you had approved, something like that. Those types of things are conflicts of interest. Anything where it can look like you did something or did not do something in exchange for some sort of monetary gain, or even maybe some sort of social or other type of personal gain. Gifts and gratuities are a little bit less esoteric. I mean, you simply can't accept any type of gifts or compensation in exchange for or related to your work as a commissioner. You are allowed to, obviously, if the city brings in dinner for you at a meeting, those types of things don't count as a gift under the code of ethics. But you certainly, you wouldn't want to accept a gift from a developer after they, as a thank you for approving their project permit. That would certainly be a violation of the code of ethics. You can simply say, "Oh, I'm so sorry. I thank you very much, but I'm a public officer and I can't accept that." It's it's a little awkward. It's never doesn't feel good to have to turn down gifts. People do sometimes actually get offended by it. I've been in that position before, but most of the time I'd say people are very, very understanding of that. And then there are some restrictions on political activity. These really relate more to employees of the body, but they can also affect you as commissioners. You can't use city facilities for any type of campaigning purposes. So if you're going to run for another office, you can't campaign or do a stump speech at a commission meeting. You can't really really talk about those types of things in the public meetings. You can't try to solicit campaign contributions on city time or city property, and holding other offices that would be that would interfere with your office as a development commissioner would also be inappropriate. The Code of Ethics also reiterates the importance of the topics that Tisha has already gone over with you, which are open meetings and public records, which just goes to show how important those issues are to both the city and the state as a whole. Next slide. And there is an acknowledgement form that you all must sign as commissioners that acknowledges that you have read the policy. And this is just a link to it. I'm assume that many, if not all of you, have already done that.
All right, thank you, Rachel. I'm going to jump in for this next topic, which is just, and again, if there are questions, please let someone know, and we'll pause. I'm just going to spend a little bit of time talking about the role of members. This is just about some expectations for you as you serve as commissioners on the Development Commission. So these are the three things that I will quickly cover. So the first is attendance, and this is important because, as you probably gathered, for those of you who've served on the commission, you are a piece in a very big timeline for these projects and issues, and so it's important that we know if you need to miss a meeting so we can ensure that there is still a quorum present. So please provide Lucy or Minnie or your point person at the planning department notice of travel, even if it might not conflict with a scheduled meeting. At times special meetings are needed, so it can be helpful to know if you're going to be gone for a 2-week period. We request 5-day notice. Understand that's not always possible. If you have some kind of emergency or health issue, just do your best to provide any kind of advance notice so that you can be indicated as having an excused absence. That's important because if you provide no advance notice, your absence is considered unexcused. If you have 3 consecutive unexcused absences, that can be cause to be removed from the commission. So again, we understand you may not be able to be at every meeting, just to provide that notice. I wanted to take a minute to talk about the transition to in-person meetings, as I know you've all received a few emails over the last couple of weeks talking about plans to initially return to in-person meetings in June, and then because of the high COVID case counts in the area, recently the city and the mayor's office has decided to delay that to June. So we have 14 advisory boards in the city and are planning at this time that 6 of them would return in person starting in July. I'm uncertain if your July 6th meeting is needed, and so I've listed both that and your planned joint meeting with PPC, which is occurring on the 14th. One of those will be your first in-person meeting. The meetings will be held in the council chambers again, and you will be seated up at the dais. The Development Commission has been determined to be one of the commissions that the city would like to continue to provide virtual participation for. So let me stop for a minute there. We there was during when COVID hit, there were no provisions for a purely remote meeting of our city council or our advisory boards. But the governor very quickly issued a proclamation that said that virtual meetings were required during COVID, in-person meetings were optional. And so for the past 2 years, we've been operating under that proclamation, which has been extended and approved by the legislature. That proclamation is being terminated as of June 1st. So as of June 1st, in-person meetings will be required. Virtual components to those meetings will be optional, unless we continue to be in a state of emergency and there's a demonstrated public health and safety need. So for the month of June, we'll be using that provision, saying that we have a continued public health and safety need to have your meetings fully virtual. And then in July, we'll be expecting that board and commission members return in person for those first 6 boards, but we'll be allowing the public to continue to participate virtually. And I foresee that that could be on an ongoing basis. We've seen the public, in some cases, increased public participation because of that virtual component. So I wanted to provide an opportunity for any questions, and also to remind you, during COVID, attendance by board and commission members has been absolutely stellar, because many of us have been home and we've been able to participate in meetings even when we're not, in Issaquah. But obviously, returning to in-person meetings means that you will have travel, you may be ill, and just provide that advance notice to staff. We understand there will be an increase in that need for excused absences. And again, if you have any questions on this point, let me know. Otherwise, I'll move on to the last few slides I have. All right, so just quickly touching on the role of alternates on the commission. This can be a point of confusion. Melanie, I see that you are a regular member and that Eddie is an alternate member, so this is a good point for him to listen to. So alternates have expectations to attend meetings and are such a valuable part of the commission, because in the absence of any regular member, they're asked to step in and fill those shoes. However, if there are all 7 regular members present at a meeting and there is a discussion and decision on an issue, while the alternate can participate in discussion, once a motion is made, they are not able to participate in debate. They're not able to make a motion, participate in debate, or vote. So there are some limitations to their role if they are not filling in as a regular member. And the Development Commission rules have some provisions for which alternates are selected to fill in place of regular members. It's based on seniority, if I recall. And typically, the staff liaison will reach out in advance if it's known that an alternate will need to fill in. The meeting agendas are all published online, as I mentioned earlier. There are some action indicators on those agendas that can be helpful. An IDA, which are code for information, discussion, and action. So those are useful to pay attention to when you're reviewing the agenda. And here is a sample of what the agenda looks like. It contains hyperlinks to the staff reports and materials that are accompanying the items that you are to be discussing at your meeting. With that, I'm going to turn it back over to Rachel.
Unmute myself. Thanks, Tisha. All right, now to discuss public hearings, which I know that you have all had your fair share of. Let's see, you could advance the slide, Tisha. Thank you. There are 2 types of public hearings that we deal with in local government. The first type is legislative, where the objective is to obtain public input on legislative policy matters. The other is quasi-judicial, where the objective is to decide the legal rights of specific individual parties in a specific matter. Those are the decisions that, in the public hearings, that this group is probably most familiar with. Next slide. In legislative hearings, you act like a legislator. You make decisions that affect the entire community as a whole. These public hearings of a legislative nature, just like the quasi-judicial ones, require notice. They require a reasonable opportunity to be heard. The amount of notice that the city has to provide depends on the nature of the hearing and what it's about. And it's usually found in either the IMC or in one of the state statutes, the RCW. The notice has to describe the action that's under consideration with enough specificity to allow people of ordinary intelligence, is what the law says, to understand what will and will not be discussed in that public hearing. Not every legislative decision is subject to a public hearing. It's really dependent on whether or not a state statute or a local code requires it. Some cities then choose to, add more public hearings than are necessary by either their code or the state statutes. But there are only certain particular legislative actions that actually require the public hearing. Otherwise, people still have the opportunity to be heard, but it's just in the form of the regular public comment process. What does it mean to have the opportunity to be heard? It means that at a public hearing, all members of the public have to be allowed to speak. You can establish reasonable rules, so you don't have to let someone speak for 45 minutes, and you can keep them on track. They don't get up and read the phone book or something like that. And of course, you can have somewhat have decorum rules. Those are a little hard to enforce, to be quite frank. Under the First Amendment, people have to be pretty poorly behaved in public meetings in order for us to kick them out. But in general, we can shut down some pretty inappropriate behavior that's going on. And the best way to obtain the appropriate behavior at the outset is for the chair to establish the ground rules at the onset, so people know how long they have to speak, and that they need to stay on focus and on point and be relevant, and that they're, you know, that they're supposed to direct their comments to the entire body. Those types of rules, no personal attacks. That's why you'll see and hear those things a lot in meetings. Is those are just the chair of the meeting establishing those ground rules. Legislative hearings are essentially they're to obtain the public input, but it's so that so that the legislative body can make its decision, usually on criteria that is set by either state law or city code. In the absence of such set criteria, it's what's called a policy decision, which means that it's that body deciding what the best policy is for that particular community. They are not limited to considering the testimony and documents presented at the hearing. So in other words, it's not a closed record hearing like you're often hear about in quasi-judicial matters. It's open, and they can go out and talk to whoever in the public that they want to. They can go read and do their own research. There's really just no parameters on how much input and testimony and information they can seek before making their decision. Quasi-judicial decisions, on the other hand, are much different. In those hearings, the body is acting like a court. They are holding the hearings essentially to gather evidence. That evidence is your record. They then make findings based on that evidence / record. And they make those findings by applying criteria, whether it be permit criteria or other decision criteria, to the facts that are in the evidence, to then draw conclusions on whether or not an approval should be granted, and to decide the rights of various applicants in these types of proceedings. It is very, very good comparison to court, where judges is looking to see, did you meet the elements of this offense, let's say, if it's a crime. So it's very much like that, but held outside of court. To have a proper quasi-judicial proceeding, you really should have standing rules of procedure. It keeps things moving smoothly, but it also ensures that we can make that everyone gets the appropriate due process, which we'll talk about in a few slides from here. But in the absence of having standing rules, on the books that you use every time, you can work out procedures at the outset of a meeting on how you're going to do it, at the outset of the hearings. So the important thing is that you're not just going in and winging it, and that you have an established process up front so that the proceedings are orderly, fair, judicious. Typically, the party that has the burden of proof is what we call it, which is usually in cases where there is an applicant. It would be the applicant, anyone who's applying for a permit or some sort of approval, they would present first. And then the other parties who were anyone who was contesting that, they would then present afterwards. And then the first initial party would then have an opportunity to rebut the other speakers. Commissioners are allowed to ask questions at any time during these proceedings, just like a judge can and does do, in fact. Quasi-judicial decisions are subject to what is called the appearance of fairness doctrine. Under the appearance of fairness doctrine, proceedings must be fair and appear fair. So they have to be fair in what we call in appearance and fact. This questions that you ask to determine whether or not there has been a violation of the appearance of fairness doctrine, or whether or not something is in fact fair, is Was the decision made solely on the basis of matters that are in the record? Would a fair-minded person observing the proceedings be able to conclude that everyone who needed to be heard had been heard? Did the decision makers give reasonable faith and credit to all matters presented according to the weight and force that those matters were entitled to receive? So on that note, it means that you have to make credibility determinations and relevance determinations, just like a judge has to do when they weigh the evidence. Not everything that you're going to hear in a quasi-judicial hearing, just like in a legislative hearing, really, is going to be relevant or as credible as other information that you might hear. And one of your jobs as a decision maker is to, evaluate the credentials and knowledge of the speakers and the relevance of the particular speakers to whatever you're deciding and to the particular criteria that you need to, that are applicable to the decision. Because once again, not everything, people may have very valid points when they stand up to speak, but it doesn't necessarily mean that it is relevant to that particular proceeding. The ultimate question that a judge asks in these proceedings is whether a reasonably prudent and disinterested observer would conclude that all parties obtained a fair, impartial, and neutral hearing. So to this end, ex parte communications are prohibited, which means that you can't have out of proceedings, out of hearing contact with proponents or opponents of a particular project. There's a special scrutiny on the relationship of the decision makers to a particular project, which is why you get asked those lovely questions that the staff will ask you. I think we can go to the next slide now. Thank you. Because there's a lot of case law. The appearance of fairness doctrine was initially established by case law. It's been codified now, so it's actually in the RCW, but it wasn't always. So there's a lot of cases that discuss, what the appearance of fairness doctrine means and the various violations that can occur. And there are many ways that you can have an interest in a particular project. For instance, perhaps maybe you have some sort of personal or social connection to a project that might cause you to prejudge the issue or might bias you to a particular one particular party over another. That's really the key. The key question is whether or not you can, despite any particular connections that you have to the project, whether or not you can fairly and impartially hear the matter. Ex parte communications can be cured by disclosing the substance of your communications at the outset of the hearing and then giving the opportunity for members of the public that are there to rebut and challenge you. And at that point, you have the opportunity to then step down and essentially leave the room and not participate in the decision any longer or in the proceedings any longer, or to say, no, I stay by my position. Yes, I had these ex parte communications, but I do not feel that they bias me in any way. Other appearance of fairness problems can't be cured in the same way that ex parte communications can. However, once again, if you don't feel that something has impacted your ability to be fair and impartial, then you can, as long as it's been disclosed, for instance, you say, my friend is on the board of this organization. As long as you've disclosed that and given the opportunity for someone to challenge it, if they don't challenge it at that hearing, their objection is waived. And if they do challenge it, once again, and you are feel strong in your conviction that you are not biased because of it, you can still participate. Another really interesting feature of the appearance of fairness doctrine is the rule of necessity, which does come up from time to time, and it holds that if all members of, or if a quorum or more essentially of a decision-making body are essentially conflicted out because of appearance of fairness issues, then they can still participate in the decision because they have to. It's a necessity. Otherwise, the decision couldn't be made. So that's just something to keep in mind. I've rarely seen it have to be invoked, but I have from time to time. Next slide. Deliberations on a quasi-judicial decision can happen immediately following the hearing, or you can have them at a subsequent date. It's usually good to hold them as close to the end of the hearing as possible, just to avoid allegations of interference in the interim. The decisions must be based on the criteria. So in this case, the criteria that's in the code. There, like I said a few minutes ago, there may be, people may raise excellent points for or against a project, but those points are just not relevant unless they go to a particular code criteria. The decision also has to be based on items that are in the record, means the testimony, comments, the documents that have been introduced into the record. So for instance, let's say you know something, you just happen to know something about a particular property or project. If it's outside of the record, even if it really helps tip the balance for you one way or the other, you can't rely on that in making your decision because it's not in the record. Next slide. Thank you. Legal challenges. There's a couple types of legal challenges we see to land use decisions. There are legal challenges, they both really relate to due process, which due process is it's a constitutional right and theory, which is that parties must be given adequate notice and a meaningful opportunity to be heard. And to obtain due process in these proceedings means that we have to follow the process that is in the code. That's procedural due process. There's, once again, I should step back. There are two types of due process. There's procedural due process and substantive due process. Procedural due process means that you follow the correct steps. Substantive due process means that the legislation serves a legitimate purpose, or decision serves a legitimate purpose and is not made arbitrarily or irrationally. So on one hand, you have to make sure that you follow the correct procedures to give due process on that, in that regard. You also have to make sure that you give due process in the form of not rendering decisions that are arbitrary and capricious. Where we see most of our challenges end up is in court under Land Use Petition Act cases. We do see cases in front of other bodies too, like the Growth Board, but the vast majority of decisions that you're going to be involved in are going to be heard under LUPA, because LUPA is where appeals of quasi-judicial matters go. And LUPA provides people with an opportunity to appeal a land use decision within 21 days of the issuance of that decision. The court reviews the permit decision to determine if it's supported by substantial evidence, if it's based on evidence in the record, if there was an erroneous interpretation of law involved, or an erroneous application of the law to the facts, and essentially, you didn't actually meet those criteria, would be how that would work. That was based on some sort of procedural error. So, for instance, you didn't follow the policies and procedures for how to conduct the meeting. So maybe you didn't. For instance, an error like that would be that something wasn't noticed properly, or that it was outside of the jurisdiction of the decision maker. For instance, if the Development Commission made a decision that should have been rendered by the hearing examiner, or vice versa. Or of course, if it violates the constitutional rights of any of the parties involved. LUPA decisions are reviewed on the record and no new evidence is taken by the court, which is in most cases. There are certain cases where the court will allow additional evidence into the record, and as lawyers, we all are very sad when that happens because the record in LUPA proceedings is already thousands and thousands and thousands and thousands of pages long. So there's plenty of evidence already for everyone to fight over, and doing adding more is, one of the nice things about LUPA is that the decisions are rather streamlined because of that's the entire purpose, is to give applicants more certainty on their projects in a quick and timely manner. And because of that, you don't engage in the same type of discovery you do in regular civil litigation, because you just have the record. And with that, I will be happy to take any questions.
Are there any questions on this part of the presentation this evening from commissioners? Commissioner Morgan.
Thank you, Chair Brennan. I do have a few questions, if it's okay. Time limits for speakers. So in a meeting, it sounds like it's up to the discretion of the chair. And if you had a meeting that you had a long list of people speaking, is there a minimum time limit that a chair has to provide somebody to speak?
There's no minimum set in law particularly, but it would come down to that. It would be sort of a due process issue. Did they get a meaningful opportunity to be heard? I would say in general, 3 minutes is about the minimum I've seen provided per each speaker, which in some cases, even that can lead to some very, very lengthy meetings, but it's better to err on the side of caution, I think, when it comes to giving people an opportunity to be heard, given how important that is to the overall process.
Great, thank you.
Sure.
Could I add one thing? Just because I want to make sure that commissioners remember that we do have adopted rules of procedure. And those rules say that we will give 5 minutes, but that we can shorten the time based on the number of speakers who are present. And so it's helpful. I think it's a great question about what the minimum is, because there are times, such as in recent history, in which we've had a lot of speakers and needed to parse out the time that's available.
That's a very good point, Lucy. Thank you.
My second question, the appearance of fairness and the disclosure. And my understanding now is that with like with the Providence Point high school project, we make disclosures at each meeting that comes up. And I thought it used to be where it was you would make a disclosure at the beginning of a project, and if it got continued, if there'd been no objections in the beginning, that just held throughout. But it could be objected at each meeting now, as I understand.
It's really more of I think that's just to provide additional protection to the city and to make sure that if you have different people attending on different nights, they get the opportunity to object on those evenings. Because what you wouldn't want to have is if you continued it to another date and somebody else hadn't been there the first day and didn't hear the disclosures, then you might get into an argument in your LUPA about whether or not those disclosures carried over, which I think that honestly they probably would, but it's just I think it's more of a cautionary way to handle it and just a matter of transparency.
Great, thank you. And the last one is, oh, sorry.
I asked one more question. I had wondered whether it had the repetition of appearance of fairness disclosures was also to address the potential for ex parte communication between meetings.
It's true. I mean, you could have additional ex parte communications. I mean, yes, that's definitely, you could do something simpler, I suppose, though, like say, does anyone have, just throw the slide up and say, does anyone else have anything that they didn't disclose last time? I mean, I suppose you don't really have to ask everyone the questions every time is kind of what I mean, but I think it's a good idea to just do the whole process each time, because I mean, technically you could have even moved to a home, to a place that's within 300 feet of a property with it between the two meetings. I mean, or got employment with someone. So those things can change over the course of a project. So it's just better to check in than to
Okay.
just,
And then last question, the work where we're helping out with the PPC on Title 18, I presume then that falls under the legislative
yes.
branches. So there is no quasi judicial, there's no disclosure or issues with discussion outside the meeting. If somebody came up to you and wanted to give you their opinion of Title 18 outside of a meeting.
You are free to discuss it and to solicit all the feedback that you would like to solicit.
Okay.
Yep. None of the same quasi judicial parameters. There's no appearance of fairness issue there, just a purely legislative decision. So yes, you are absolutely free to look into it as much as you want to and talk to people at the grocery store, and yep.
Okay. Thanks, Rachel.
Are there any other questions from commissioners after realizing that the PPC has it so much easier than we do? So Commissioner Sanford.
For sure, we do have it easier. Back in the day when we were meeting in person, and I guess we will again soon, maybe one day, when members of the public signed up to speak and they would come to the lectern, we would ask them to state their name and address. And there was, I think, a point in time when we dropped the address. Maybe this is in our rules of procedure that Lucy referred to, I don't know. So do we just ask them to give their name? Is that all we ask?
Yes. I mean, I will tell you that surprising number of jurisdictions still request the whole thing, but it's not something that people are required to give. So my advice is to not ask that.
Okay, thanks.
Are there other questions from the commission on this topic? Okay, seeing none. Lucy, I know we don't have a project in front of us tonight, but I did move quickly at the beginning and skip past the opportunity for public comment. Don't know that we've got anybody on the call with us this evening, but I do want to give an opportunity if there is somebody on the call that would like to comment, an opportunity to do that now.
There are no attendees at the meeting other than the panelists.
Great, thank you for that. Okay, so we'll move on to the next topic. And Lucy, I think you are the presenter on this one on resources, codes, and permit types.
Can you see my screen?
Yes, we can.
Okay, fantastic. So tonight I'm going to walk through some sort of more specific information related to what the attorney Rachel and City Clerk Tisha have presented this evening. So one of the things that I have been asked in the past is how the commission fits into the organizational structure. So we are, both staff and the commission are part of the administration. Staff often receive or always receive the permits first. For some permits, we are the decision makers. In other cases, we're making recommendations. Those recommendations can be to the Development Commission, to the Planning Policy Commission, or to the City Council. Or we can even make, right to council, sorry. The Development Commission sometimes makes decisions and sometimes makes recommendations again to council. And likewise, Planning Policy Commission is almost always making recommendations to council. All of those are in code. So these are processes that are laid out. The use of the Development Commission in consulting, actually, you're almost like a content expert to the Planning Policy Commission. That's why we're doing joint meetings with many different boards and commissions as content experts to support PPC in making their recommendations. So now I'm going to kind of go through in more detail what that means for staff and the commission in terms of permits and review process. Then we'll talk about resources. We will have an introduction of commissioners and then conclude with our elections. What I'm going to talk about this evening are existing permit types and processes. As many of you are aware, we're overhauling Title 18, which is the land use code. So in the next year, some of this may be different, but for any permits that become before you, before that happens, we will still be using the processes and permits in place. So the three ones that I'll highlight tonight are site development permits, or SDPs, master site plans, or MSPs, and community conferences. Site development permits are triggered depending on where they are in the city by property size, building size, or street frontage. You are the decision maker, and it is a quasi-judicial process. For master site plans in certain parts of the city, such as where the high school and elementary school at Providence Heights were located, if a project has more than 15 acres, it has to have a master site plan. And in that case, you are making a recommendation to council, again, in a quasi-judicial process. The third type I identified for this evening is a community conference. This is not a decision-making process. It is advisory. It's kind of an early consultation on either a master site plan or a site development permit, and there is no decision. Feel free to just turn your mics on and let me know if you have a question along the way. This is pretty informal. So now I want to sort of lay out what this process is, where those pieces might fit in, and I'll just kind of keep diving into a little bit more detail. So when someone comes to the city and says they're interested in a project, we start with a fairly informal process. So we might have an introductory meeting, and we also have something called a collaboration. At a collaboration, we may make sure they're using the right codes, get to know what their project is, their timelines, and just to have those kinds of general discussions. Then there's a more structured phase to the project. One step might be a pre-application meeting called a pre-app. There are submittal requirements. We would have a meeting and give the city reviewers would give feedback to the applicant team. Then they would make a formal submittal for a site development permit or master site plan. In some cases, a community conference, as I mentioned, is required, and it would fall in this kind of in between the pre-app and the full submittal of the land use permit. Once we've gotten this, we move on to a staff report. The commission would review that, take public comment at public hearing. The commission action would then take place. If it's a recommendation, it would go to council, and then either the commission's decision or the council's decision could be appealed. Assuming that it is recommended for approval or it is approved, once that this phase is completed, we move into the construction phase, which would include construction permits, actual construction inspection, and occupancy. So the commission's portion of this is really once the site development permit or master site plan are submitted, staff then review it in detail and write a staff report. Your piece of it is once we've sent the staff report to you, holding the public hearing, and then making the decision or recommendation. This is kind of the most detailed version. This is the way we have done it in the past. As I mentioned, Title 18 may change much of this. Also, with a new city attorney and new director, there may be some tweaks to this even in the next year before Title 18 is adopted. But and I'm presenting this mostly so we just all have a baseline for changes in case they come. About a week before the commission meeting, we issued the staff report and the packet. The first part of the public hearing is the project is introduced to you by staff and the applicant. We get questions from the commissioners and the public. Then staff often prepare a briefing response memo where we summarize the questions and concerns that we've heard raised and provide responses and potentially edit or add conditions. And then in the second part of the public hearing, we take responses, we review the responses, we take testimony, complete creating the record on which you're going to make a decision and make a decision. Then staff prepares a notice of decision or recommendation and the chairperson for the chairperson's signature. Looking ahead, the three things I would point out here, you are the stakeholder on 3 out of the 6 Title 18 buckets, buckets 3, 4, and 5. You can see the topics there. We last year did a gap analysis with you in PPC on those 3 buckets. This year we are bringing discussion drafts on those of all the content of those buckets. I should say for Melanie's sake that when we say buckets, there are about 22 or 23 chapters in Title 18, which is the land use code. And we've divided all of that content into buckets of related content and pairing content experts like the Parks Board, the Environmental Board, and the Development Commission as to support Planning Policy Commission in reviewing that. So their Development Commission uses the code more than almost anyone. And so that's why there are 3 buckets that you are associated with. We, as you all know all too well, last week was the bucket 3 zoning and uses discussion draft hearing. There will be another hearing in June on building and site and urban design. And then July will be development standards. We have upcoming 3 permits that have been submitted that will come to the Development Commission. Those are not scheduled at this time. We will coordinate with you in advance and set up meeting dates for those when they're ready to come to the Commission. Along with sending you the packet, we also include a calendar with the packet. That's one way we try and keep you apprised of what's coming in the future. And it's not unusual, as many commissioners know, to have several months when we don't have meetings. So we usually try and send an email in those months, kind of updating you on what's coming, what's happened with things that have been before you, just to keep you kind of apprised. Any questions? Commissioner Morgan?
Yeah, thank you, Lucy. A question on the ex parte communication and community conferences versus SDP. Does it kick in as soon as we get notice of a community conference, or is it not till the SDP notice, or?
I'm going to phone a friend, and I think that I know the answer, but I would prefer that Rachel give it just in case I'm wrong.
I would say that it would, I mean, it technically, it comes in as soon as any type of application comes in, so it would come in as soon as the community conference.
Great, thank you.
Sure.
And that's the exact answer Lucy would have given too, I'm sure. So are there other questions for Lucy on this topic? I can't see everyone, so you'll need to speak up if there are, but I'm not seeing the people I can see or the commissioners I can see. I'm not seeing any hands.
I have a quick question. Just because I'm new here. How much time usually elapses between the first and second hearings?
Right. So usually, as Rachel was saying, we like to not have too much time between them. It could be as short as 2 weeks, might be a month. It depends on the complexity of the kinds of questions and concerns that were raised.
Good question. Are there other questions for Lucy? Hearing none. So Lucy, do we have another topic that you're presenting on, or did you cover the?
I was going to talk about resources for a minute.
Okay.
So, you know, there's a lot that you've heard about tonight. We try and provide a robust staff report, but we also want commissioners to be able to sort of check the code, understand things within the context of the code that is being reviewed. And you may also just be curious about the city, so I want to provide some resources. First is just going to the city's website, issaquah.gov. You can always search for things. I hear the search bar is pretty good. And you can also sign up for Notify Me. There are various topics that you can select, community topics, neighborhood topics, if you're interested. We have an active projects map, which we use to help the public be informed about projects and to get information on them. The map part of it is currently down, but if you go to issaquah.gov/development, the list is available. In terms of codes, if you want to look at a code, if you go to our website under your government, under documents, you can look at either city code standards and plans, and you can see the kinds of resources that are available, or you can go to the municipal code and click through to see, in particular, the land use code. When you get to code publishing, you would click on Title 18, and these are all the chapters that are located there. Some of the ones that might be relevant are either 1806 on zoning, which includes permitted uses, or the development standards in 1807. A lot of the projects that come before you are in central Issaquah, and I'll show you how to get to that. It is not part of code publishing. That's part of the reason that we're undertaking the overhaul, is to pull all the codes into a single code and have it all at code publishing to make it easy to find. So for those codes that are only hosted on our website, you would go to, sorry, I have to stay signed in or it'll kick me off. You would go to the document center. You might go there from that plans and standards page, and either open development and Central Issaquah to get to any of the Central Issaquah standards. You also sometimes get things that are within development agreement areas, and you would expand the development agreements, and you can see the kind of list of identify the development agreement, and again, be able to see the agreement and its various appendices. If you're interested in finding out when your term ends, to contact your liaison, to find out when meetings are, or get to the packet or the rules, you would again go to your government, boards and commissions, development, and I will send out this PowerPoint so that you have it as a resource. The liaison contact is at the top. The regular and alternate members are listed with their terms. The time and location of meetings, past meeting packets are available. Current meetings are listed here, and the rules and regulations are listed there. Any questions on resources?
Hearing none. Thanks, that was helpful, Lucy. Yeah, I think the city's website is, it's a great place to go to find information. Once you use it a few times, it becomes a little easier to navigate, but it's not bad, and the search bar is a pretty effective tool as well, so appreciate that. So does that cover the topic B on our agenda, Lucy?
Commissioner, Chair Brennan, I do have one quick question.
Sure.
It showed the development agreement for the Highlands. For some reason, I thought the Highlands development agreement expire. Does it stay in place, or?
The Highlands agreement has been terminated, as have several of the agreements that are listed there. We just still have them available on our website because sometimes there's parts of those that are relevant or useful.
Okay.
So Talus, Issaquah Highlands, I think it's listed on there as Highlands TOD, and most of the WashDOT TDR development agreements have been terminated or modified.
Great. Thank you.
Yeah. And yes, that completes under regular business item B.
Okay. We did have one item, the Development Commission get acquainted. We do have one new member with us this evening. It might be Commissioner Gilbert. We know you joined us at the joint meeting with the PPC, but this is the first meeting with the Development Commission, so we want to welcome you. It might be helpful for Commissioner Gilbert just to maybe just hear a few words from each of the development commissioners. Maybe, I think she probably knows your name now, but at least a little bit about your tenure with the commission and anything you want to share about your background. So I'll just call on commission members, and I'll go randomly, but I'll start with Commissioner Morgan.
Thank you, Chair Brennan. It's great to have another Mel on the commission, obviously. I have been a member of the commission since 1995. So there have seen a lot of changes take place in the city, and it's been an amazing journey, I think. And Issaquah is very unique, I think, in the fact that we allow people like us to have input on what goes on in the city. My background was in commercial real estate appraisal, and so it was a skill that I thought might be helpful with regard to real estate. And I'm just find real estate kind of an interesting thing, which is probably a geeky thing, but and I have to say the staff does a wonderful job, I think, helping us through the whole process and all of this. So welcome to the commission, Melanie.
Thank you.
Vice Chair Price.
Hi, thank you. Welcome, Melanie. Thank you for joining us. You're going to have a lot of fun here. My name is Kevin Price. As you probably know by now, I've been on the commission since 2016, I believe, which seems like yesterday. Doesn't feel like it's been that long. I'm an architect. I design custom residential homes, mostly throughout the region. Once in a great while, I have an opportunity to do something outside the state, but that's rare. So again, thank you and welcome, and I look forward to serving with you.
Commissioner Shore.
Hello and welcome. My name is Brooke Shore. I've been on the commission for about 3 years now, and I'm a civil engineer working for a general contractor in the area.
Commissioner Dillon.
Hi, I'm Patty Dillon. I just am finishing my first year on the commission, so I remember this same meeting last year, and it feels a lot less overwhelming at this point than it did then. So a lot of the staff really take care of us in terms of providing the information that we need and making sure that we're remembering the rules and policies and staying on track. I'm also a civil engineer. I work for a water resources consulting firm, and have a lot of interest in our streams and natural environment in Issaquah. So bringing a little bit of a different perspective to the Development Commission.
Commissioner Sanford.
Hi, my name is Richard Sanford. I've been on the commission for 5 years, and I recently re-upped. I applied again for some crazy reason. This thing kind of grows on you, you'll find out. My professional background was in technical communication and some project management, mainly in tech and aviation. So I had nothing at all to do with background in land use or anything like it. So I thought this would be a good thing to do in retirement. And I saw a little piece on the slide there about hobbies. I write some fiction on the side, and I'm currently torturing myself trying to learn finger picking on guitar, which is something I should have done at a much more age appropriate time, but that's the way it is.
So I guess that leaves me. So welcome, Commissioner Gilbert. I'm Mike Brennan, currently serving as the chair. I've been on the commission for over 10 years. I've re-upped a few times along the way, similar to a couple others on the meeting this evening. I've been in public service for my adult career, so to speak, working for county and city in the Puget Sound area for the last 35 years, I think, long time. In the development side, in development services, so involved in a lot of development related activities, land use actions, code updates, community outreach, etc. So kind of carry my day job into my night job here. And I really enjoy serving on the commission. And as has been said, the staff are wonderful to work with. If you have questions or you wonder about anything, feel free to reach out to Lucy or any of the other staff that come to commission meetings to present, or any of us. It's not a problem to shoot an email out to any of us if you have a question. Make sure we're following the rules about that. We don't want to have a serial meeting outside, but when it just comes to a simple question, a one-on-one, email to somebody is fine and helpful, even if it's like procedural questions. So we want to also hear maybe a little bit about you as our new commission member.
Thank you. It's really nice to meet all of you. Well, I'm an architect and I'm not currently working. I've taken some time off from work, and I have young kids, so I don't have a whole lot of hobbies right now. So, but I've been in Washington for 5 years, and I also studied historic preservation, and really just wanted to get involved in keeping Issaquah a great place to live. So it's really nice to be here.
Great. It's great to have you. And you'll get the rhythm after we get going here. And I think once we get back into in-person meetings, it's a little easier to connect and kind of facilitate things. But I think we've done great work and again, a lot of help from the staff over the last 2 years in the virtual environment. But hopefully soon we'll be back in person. So Lucy, do we have anything else that you had planned prior to the election of officers? No? Okay, so our next agenda topic is the election of officers. This generally happens in May. And then the people serving as the chair and the vice chair serve for a year, and then next year at around this time we'll be doing elections once again. So we'll use the following process to elect the officers, the chair and the vice chair. First, I'll call for nominations, and when all the nominations have been made, I'll close the nominations. If there is just one nomination, then that member would be considered elected to that position by a unanimous consent of the commission. If we have multiple nominations, commission members are provided an opportunity to discuss the nominees. I'll ask commission members to cast votes on the nominees in the order they were nominated by a roll call. Commission members may vote for only one nominee per office and may vote for themselves. The first commission member receiving a majority vote is then declared the chair. So the process then will begin with the chair, and then we'll follow that with the election of the vice chair. We'll begin by, are there any nominations for the chair? Just go ahead and unmute and make a nomination if you'd like to.
Mr. Chair, this is Kevin Price speaking. I would like to make a nomination for Richard Sanford as the position of chair.
Thank you, Commissioner Price. Are there other nominations for chair? Are there any other nominations for chair? Hearing none. Commissioner Sanford, congratulations. You have been elected by consensus as our new chair. So, Mr. Chair, I hand the gavel to you to manage the election of the vice chair.
Thank you, I think, Mr. Former Chair. Yeah. Okay, then are there any nominations for the vice chair?
Mr. Chair, I would like to nominate Brooke Shore as vice chair.
Are there any other nominations? Any other nominations for vice chair? Hearing none, the nominations are closed. Commissioner Shore, you've been elected vice chair through about this time next year. Congratulations.
All right.
Thanks. Hopefully you always show up.
Can promise nothing. Okay, I guess we have another item of business, a couple of more on our agenda tonight. Director Dollywall, is Director Dollywall present with any city council update?
Good evening, commissioners. Congratulations to the new chair and vice chair. And thank you for all the work you've done on Title 18. That's moving through the city council process. So we've been going and checking in with them after each major topic area, which you all haven't been involved in the first two, but the uses and zoning and all those form and intensity stuff will go to them. Nothing more to report from council. The other thing that they're working on are code enforcement procedures. So we are taking that forward for amendment and having a more process-oriented update where things are going to the hearing examiner, giving people due process, because having the code is one thing, but having good tools to enforce it is going to be also critical. So that's what's going on with City Council. Yep, that's all I have in terms of report. It was great to see all the process, all our discussion today for resources. One of the things I think we've internally discussed that we probably should get your feedback on is the form, once we get the new Title 18 code update and give you the better tools for what's within your purview, what's the criteria that you're looking at and all of that. but also staff report, the way we format it, if we have it under findings, conclusions and recommendations, then we're not having to go back and recreate a document that we have the chair sign. So that's something we're considering, that the first report that you get it in that format. And then if any changes that you all make during your deliberations, we capture those through motions that are captured in the minutes to streamline the process a little bit, to not have too many meetings for you all. We want to be respectful of your time, but also scale of the project. So some projects will obviously require multiple hearings, but smaller ones perhaps don't. So as we move forward with some of the projects that we bring forward, we're looking at the format of the staff report and such.
Thank you, Director. Lucy, did you have any other points on the schedule going forward, the calendar going forward? You mentioned it briefly in your presentation, but I wondered if you wanted to go over the calendar.
Well, it's really, if the commissioners have any questions, your next meeting is scheduled May 12th. No, that was the one we had last week. June 9th will be your next meeting with the Planning Policy Commission on the building and site design. We anticipate releasing that bucket the beginning of next week. So you will have a couple of weeks to review the content before the meeting. Are there any questions on schedule? Okay. So one other announcement, this is my last Development Commission meeting. I am leaving the city at the end of the month. I want to thank you all. I have really enjoyed very, very much being the liaison for this commission because you are a wonderfully engaged group, and it's really been a pleasure to serve you in that role.
Are there any other comments or business from the commission? Commissioner Brennan?
We can't let Lucy just
No,
walk into the sunset.
I'm sorry, there will be no adjournment to this meeting.
No, Lucy, wow. Well, I'm not sure where your journey's taking you, but wherever that is, wish you, great fortune and a great experience. It has been our pleasure, my pleasure, working with you on the commission. You've been fantastic. I mean, the quality of your work and the work of your staff that you lead in the development process here has been just really exceptional. So thanks for everything you've done for us. It's made our lives much easier, much easier.
Well, thank you.
We are going to miss you.
Commissioner Morgan?
Well, first let me say, I don't want to say to get this out of the way, but I do want to say a great thank you to Commissioner Brennan and Commissioner Price for their service as chair and vice chair. And I think especially for Commissioner Brennan in feeling our way through this virtual reality of running meetings. It's a very different thing, not easy at all. And he did an excellent job of making the process smooth, in large part due to Lucy, all the work that you've done. I'm so bummed. It has been so wonderful to work with you. And I have to say, I ask a lot of crazy, stupid questions, and you always have answers to them. I've always been amazed by that. You've done just an excellent job working with us, answering questions at meetings from us and from the public and applicants. You're just a stellar person at what you do, and you will be greatly missed.
Well, thank you. That's very kind.
Commissioner Shore?
I just want to add thank you as well. I had a lot of questions coming into this, and you were very helpful. And just I'm always surprised when you answer my calls. But thank you very much.
Well, and actually, I think, thank you, Brooke. And I would encourage everyone, including our newest commissioners, Commissioner Shore did a great job. She would just send me emails with questions and leading up to meetings to help her feel confident and clear about how something worked and whether something was okay or not. And I really want to encourage all of you with whomever becomes the liaison to the committee going forward to take advantage of that, because we really enjoy answering all those fun questions you throw our way.
Commissioner Dillon?
I'd just like to add my thank you as well. I'm really glad I got a chance to meet you in person on our little downtown tour last fall, and really appreciate all the materials and information that you provided, and it's really made it a much easier process to feel engaged and part of the committee just starting out.
I'm glad. Thank you.
Any other input or discussion? Well, I'd like to add that I thought that I was only going to be thanking Commissioners Brannon and Price tonight for the fantastic job last year. But Lucy, you know, what a pro you are, how generous, how gracious you've been. And I know that we all just sincerely appreciate you. And I hope just a percentage of your knowledge is captured in the department going forward, because we will certainly need it. It'll be impossible to replace. Thank you.
Well, thank you.
Any other business before the commission tonight?
No.
Hearing none, this meeting is adjourned at 8:38. Thank you.